Now, there's no policeman that will be comfortable detaining anybody beyond 48 hours, except on matters that ordinarily the accused or committed a serious felony that ordinarily will not warrant bail. If any matter is a bailable offense, police ensures that the person is granted bail. Even though some terrible ones among them will begin to give stringent bail conditions. I've handled a matter where a policeman gave bail condition as if he was in court, as if he was acting as a judicial officer. Bring so and so number of sureties with so and so properties in so and so locations. That was in Ibadan. And then I told him, and I asked him, at the state CID, and I asked him, when have you become a judicial officer? He said, that is where we do it all. He went and brought several other examples. At the end of the day, we sorted it out. And that was not easy. And when you hear sorting it out, the accused went behind my back to give them money. You cannot stop that for now. But there is, I must tell you, there is gradual change. And it is the duty of the commissioners of police at the various states to ensure that this change is carried through.
So
that it's carried through.
1 second. It still gets back to the issue of the legal awareness.
Yes.
The awareness that the change is there.
Yes.
The awareness that this law is put in place. That this law is binding on not just these 4 components,
yes,
but the 5th component being the citizen.
And the citizen, yes.
So that education part of it. You're talking about the police reform. She raised the police thing. What about the lawyers?
The lawyers themselves. That's what I told you. I made a statement that some lawyers prefer to be masters of the loopholes of law than be masters of the law.
Would this law now take care of the loopholes?
In every law, even in this new law, there are loopholes. There are loopholes. In every law, there will be a loophole. And that is the duty of the man at the bench, to ensure that such loophole is not capitalized upon by clever lawyers to drag the process of adjudication. Even at the bench, there are also corrupt ones that tend to rub mud on the face of judiciary. And you see that a lot when there are political cases. And it is as a result of the fact that politicians themselves make every effort to corrupt the system, to gain undue advantage. But a sound man at the bench will stand his ground and dispense justice, and the justice will also be seen to have been done. Now, when you come to the other aspect of this new act, the new act needs proper legal education, not only among the officers of law, but also among the citizens. It tries to bridge whatever dichotomy that is between the North and the South, because both laws, the criminal laws of the North and the criminal laws of the South, had different original antecedents. One came down from the Maliki School of Sudan, the other one came down from the common laws of England. And then in order to try to blend both, it was difficult for the colonial masters to blend both, and they allowed both to run pari passu. And along the line, politics now came in, the culture of the people came in, the Maliki School was tried to be reinvigorated in 1990 by some politicians. Now, if you try to blend all those, it is not easy yet. But I think with consistent effort by the judicial system, there will be such blend, because this legal pluralism will not help this country. And when you talk of legal pluralism, it's not only between the North and South. It's also more terrible between the rich and the poor. And that is one that worries most activists like Wahab Shitu. That legal pluralism between the rich and the poor should not be sustained. The rich has access to justice. The poor does not.
I was going to come to that, because apart from, lawyers trying to take the area of loopholes and just take how will I describe it? Just take opportunity of that.
And prolong the system.
What about legal fees? I know every lawyer would have liberty as to how much I want to charge, but when an ordinary man needs a legal aid,
Yes.
and it comes to a lawyer.
Yes.
And then the lawyer says, gives this huge bill. How is
The legal
man?
system promotes what we call pro bono appearance. Pro bono is appear for the person giving legal services free, especially if the person is poor. And every lawyer will pride himself in giving pro bono services.
How much of lawyers would do that?
No, most lawyers do. Yes, most
Really?
lawyers do. Most lawyers do. The Legal Aid Council is there as well. It is a systemic institution that is established by act. It was then by decree, now by an act, to give legal services to the poor, especially on criminal matters. There are certain matters in court that the victim, or the accused, must have legal representation. The state can provide such legal representation for the person.
Okay,
So those are available to the poor.
Mr. Shitu, there's no way we would talk about this pro bono thing without bringing in the role of the Legal Aid Council of Nigeria. How effective would you say they've been?
Well, Legal Aid Council has been somewhat effective, but it can do better. It can be strengthened. Like, for instance, even the regulatory authorities of the legal profession now make it mandatory for every lawyer to undertake pro bono cases.
It's mandatory.
Yes, mandatory. For instance, part of the requirement for you to even be considered for elevation as a senior advocate of Nigeria, they want to know the extent to which you have been involved in prosecuting pro bono cases. I think I agree with you that part of the impediment against access to justice is the prohibitive cost of the system, including prohibitive cost of litigation,
Filing fees.
including prohibitive fees by counsel. And I think it is that realization that has compelled the regulatory authorities to say, oh, a system cannot be said to be promoting access to justice if the marginalized and vulnerable members of the society do not have access to this justice because of inadequate financial resources to hire the services of lawyers. So, and I think it's not even a credit to the lawyers themselves. It's not a credit to the administration of justice if most members of the society cannot access the justice delivery system because of funds. So I think, a lawyer who is worth the salt feels fulfilled when justice is attained. That is why there's a distinction between a lawyer and a jurist. Every good lawyer must try to be a jurist. Every good judge must also try to be a jurist. And that distinction is this: a jurist is fulfilled when justice is attained, and not when he wins his case on the basis of technicalities or at all cost. So a lawyer who is a thoroughbred professional is fulfilled when justice is attained.
Whether he loses or wins.
Notwithstanding emphasis on fees. You understand me? For instance, he's able to beat his chest, oh, I've succeeded in guaranteeing access to litigants. In spite of the fact that litigant cannot afford my fees.
Okay, when we are still at the issues of fees, I
Yes.
know that, okay, even if the lawyer decides to take the case pro bono
Yes.
without payment,
Yes.
is he also going to pay the filing fees?
No,
Because when we look at these filing fees issues, some systems, if you want to file a case at the Federal High Court, for instance, most of the prices have been increased. The fees have been increased.
it's all encompassing.
Adjusted.
It's all encompassing.
Okay.
You see, the way people do it is that before you can take up pro bono cases, you must have some degree of standing. You must be fairly comfortable yourself. A lawyer who's just coming into the profession, who does not have an income, cannot start by taking up pro bono cases. Except you want to start him out of existence. But if you are fairly comfortable and you have been in the practice of the profession for a length of time, you've made income from some other sources, you must be able to make sacrifices out of the income you have made to assist the society. Because primarily the lawyer is a social engineer.